experience, whatever we have learned with our experience as an insolvency practitioner. So regarding the tax liabilities, so I'll try to cover all the issues related to the tax liabilities. So let's start with this. The objective is to understand the interplay between IBC and tax laws, then discuss the treatment of claims of tax authorities, then applicability of TDS, and further discuss the relevant case laws. So we'll go through the moratorium and all those issues also in between. So overview of IBC is that IBC was enacted in 2016 and there are two processes, all this we know, and involves IPs, NCLT, IBBA, etc. Then statutory dues are classified as operational creditors under IBC. So this is the first thing which we need to understand, that statutory dues are covered as operational creditors. So the provisions related to operational creditors, like the provision for liquidation value in the plan, minimum liquidation value and priority of payments as applicable to the operational creditors, shall be also applied to the statutory dues. So having said that, so even in the preamble of IBC, the things were made clear that these government dues will not have a higher order in priority. So basically, when we see in the preamble, they say that the act to consolidate or amend the laws related to so and so time bound manner for maximization to promote entrepreneurship, interest of all stakeholders, including alteration in the order of priority of payment of government dues. So this is one of the item in the preamble itself. So basically, it has altered this law. It has altered the order of priority, has brought the government dues in the lower priority. So which we'll see when we see the provisions of law. Even in BLRC recommendations, it was said that it is recommended to keep the right of central state governments in the distribution waterfall in liquidation at a priority below the unsecured financial creditors, in addition to all kinds of secured creditors, for promoting availability of credit and development of a market. So basically, it is there in the preamble, it is there in BLRC recommendation, and also our law itself, Section 53, which gives the waterfall of distribution. It has placed the government dues fifth in priority, which is almost the lowest priority. So it has been given for government dues statutory creditors. So basically, the law is clear about this. Next. So this is about the priority of the this thing. Priority of the government dues. Then you will take up, now one by one the topics. So basically, firstly, we start with the claims itself. So it all starts when a claim is submitted. So Section 5, subsection 20 says that operational creditor means a person to whom operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. So this is operational creditor, and statutory dues is operational debt. So then operational debt means by virtue of Section 521, which says a claim in respect of the provision of goods and services, including employment, or a debt in respect of payment of dues arising under any law for the time being in force and payable to the central and state government or local authorities. So specifically provided in Section 521 that it is covered in operational debt. Then, in CARP provisions, so basically in the regulations, Regulation 13 says regarding the claims that the IRP RP is to verify the claims. That is all we know. Then Regulation 16 is about submission of claims, that claims are to be given or as on liquidation commencement date as far as liquidation regulations are concerned. Yeah. So, this is the provision regarding the claims. So basically, in the process of CRP, the RP would collate the claims. He has not to go inside the claims and adjudicate it. He has to collate the claims, whatever information has been provided. However, in liquidation scenario, the claims are to be adjudicated because the as per sorry, I missed it. So regulation 16, it says the person has to prove its claim. The person is to prove his claim before the liquidator. Yeah. So yeah. So person who claims to be a stakeholder shall submit its claim and update. And subregulation 2 says a person shall prove its claim for debts or dues to him. So during the liquidation, we can go deeply into the into the documents given, and we can see the assessment order, see that it has been rightly done or not. The assessment has been rightly done and all that, because in CRP, yeah, we have a limited role that we can only go through the documents and collate the claims as far as we can see the sufficiency of the documents, but not regarding the correctness of the documents. But in liquidation, definitely we can even say that that the documents are this assessment has been rightly done, or if we want to contest it, we can definitely say, yeah, so there is some issue that the charging of interest or the tax, etc., all that rates, or we can go in depth deeply into that. So this is the difference between the claims verification. So during the CRP and liquidation, then while filing the claims, the statutory authorities, they sometimes make certain mistakes, and also there are certain anomalies in the filing of the claims, like they do not file for the claim for ICD, we should say, the insolvency commencement date, and LCD, the liquidation commencement date. They file it maybe sometimes on the date of the filing of the return. They write the amount, or maybe some earlier period, maybe the end of the financial years. So while as per our law, we have to verify the claims as on the ICD or LCD. They do not provide that. This is also very gross mistake. They sometimes send it by courier or by speed post or registered post, and we do not get the contact details of the official who has signed the this thing. Sometimes there are even the email ID, they won't respond to that email ID, and that may be a general ID where it is not directly reaching the person concerned. It is for the office as in general, and you don't get response on that. Then filing without an affidavit during liquidation process, because it is required that an affidavit be filed along with the claim. Then complete documents are not there, assessment or orders, penalties, interest, etc., demand notices. So how the process of arriving at that amount underwent, that also is not fully available. While as an RP, even while we are collating the claim, we should see the basis. It is not only that whatever they have filed, we have to accept it. At least we can see the basis that yes, there is some assessment order which is of prior date and not after our public announcement or something. And assessment orders definitely must be there and completed prior to the ICD, and the relevant documents, the charging, whatever issue they have raised, and all those things should be substantiated. And during liquidation, so definitely they should give more detail, and we can call for the details from the officer concerned. Then also they charge hefty penalties, etc., even which is much above the outstanding tax amount, and to make their claim seem higher and of a larger amounts. So that is also done by the authorities. So this is about that. So basically, as far as claims are concerned, so we are definitely facing, every one of us is facing, and the litigations are numerous litigations which are related to statutory authorities because of these factors, that somewhere they make some mistakes, that claim is delayed in liquidation. We do not have power to condone. So that is there. Even in CIRP, if we do not send them admission immediately, they rush to file litigation. They won't wait. While we have to take up the such claims which are delayed beyond 90 days, such claims are to be taken up 7 days prior to the resolution plan voting. So they won't wait for that time. We have to explain them that, sir, as per CRP regulations, if a claim is filed beyond 90 days period, it will be taken up before the COC only 7 days prior to the voting starts on resolution plan. So that we have to explain. Otherwise, there are a lot of litigations which are concerning these statutory authorities, and we may have to reject their claim because of insufficiency of documents. As I told you, even the assessment orders, which is the basic document which can substantiate the volume of the claim. So that is also not filed. So for that they will go into litigations and all that. So which delays the process. And so this claim process has to be as far as government departments are concerned. What I have done in my practice, sometimes I do send people also when it is local. We do send, because these are government departments. They are not much concerned. They will just file a claim haphazardly and also not communicate. And later on, if it comes in their audit, they will file a litigation, which delays our processes. So if we take a pain seeing that, yes, government departments, they won't worry about the delays and all. So they and they don't even worry about litigation. They have just to engage some advocate on the panel, and they can do that. So better is we take pains and we communicate with them ourselves personally, and try to convince them and tell them the detailed issue why we are not. It's not only that we just send them a mail that, okay, we have admitted it or rejected it. Better would be we call them, we talk to them, and we explain them that there is such and such issue, and these are the corrective measures which you can take, so that it's only because to smoothen our own processes. So we are more concerned as RPs to have a smooth conduct of the resolution process or the liquidation. So we should take that much of effort and try to get these things handled by ourselves, and convince those departments. And we should not take it like other creditors. If they are worried about their amount, let them take the necessary steps, while I have a reason to say why I rejected. So that reason we should not keep in our own minds only. So we should convey it to them personally also, so that we don't face issues of litigation, etc. later on. And it's in our own interest of our own processes. So this much pains. We do send people also. I have sent even up to Rohtak, Bahadurgarh, and even up to Chandigarh, Panchkula in some of the matters, of Haryana GST or Haryana taxations. So even in Shimla for Himachal VAT, etc. So it's always better to, in at least for these governmental departments, that we take our own efforts and try to resolve and the things before they take any such action, such as litigation. Because once they get it in audit that there is such and such mistake, or there is a rejection from the RP, they'll immediately file an application. So this is about the claims. So then moratorium. So moratorium, basically why this topic is taken up, because our law prohibits any kind of proceedings to be instituted or continued after the insolvency commencement date. So basically not even continued. So proceedings, why we are taking up such proceedings here? Because proceedings include assessment. So even they cannot conduct any assessment post, ICD. So there are judgments which we will go through. So, therefore, moratorium is applicable, and assessments can, while we are seeing that yes, assessments are being conducted by the statutory authorities, income tax and GST and all that, even during our processes, while this is barred as per the moratorium, and even during liquidation 33 subsection 5. So when liquidation order is passed, no suit or litigation shall be instituted. So legal proceeding includes assessment there also. So the whatever dues they have to give the dues as on ICD or LCD. Not that they assess it after that, and it covers EPFO definitely. For that there is a recent NCLAT judgment, and from that we derive that yes, even the assessment of the taxation dues cannot be done after insolvency commencement and liquidation commencement, and these dues have to be taken up only as on the date of commencement of the process, so not to be assessed after the initiation of the processes. And in any case, even if they conduct the assessments, they cannot revise the claim based on that. So just for the purpose of their conducting, while they, I think it's infructuous, because in CRP, all the liabilities prior to the plan approval are extinguished as per Ghanshyam Mishra. We'll go through that case also. So it's infructuous. So they cannot even, there is no purpose of doing the assessment also, conducting the assessment. So we'll take up the example, we'll take up the judgments in this regards and try to, we can try to, discuss on this and deliberate on this issue during this presentation. So we all are insolvency professionals, and we'll make it an interactive thing later on, and maybe we can take it up in the end, because there are not much of issues. The basic issues we'll try to touch upon in the end, and try to deliberate on that. We can give our own views also in regarding whatever is being discussed there, because it's only out of our experiences, we do learn. So we'll share our experiences in the end. So moratorium, the effect of moratorium is that moratorium is intended to suspend the proceedings and coercive actions against the CD, and recovery proceedings for tax dues fall within the scope of moratorium and must be addressed under 53 of the code. As per 53(1)(e), these are to be addressed basically. In this matter of Sundaresh Bhatt, liquidator of ABG Shipyard, and versus Central Board of Direct Taxes and CBIC, Honorable Supreme Court has also clarified that tax authorities have limited jurisdiction restricted to assessment and determination of tax liabilities and cannot initiate recovery actions during moratorium. So this is regarding the recovery actions. However, very recently, NCLAT has given a judgment in this EPFO matter. So we will study this in depth, because this is a very purposeful kind of judgment. So this is dated 3rd of January in the matter of EPFO versus Jayakumar Pesumal Arlani RP of Decent Laminates versus EPFO versus and EPFO versus Sanjay Kumar Lalit RP of Apollo Soyuz. So combined judgment has been given in these two matters. So NCLAT has ruled that once CRP is underway, all proceedings against the corporate debtor are frozen, including assessment by EPFO. So this is an NCLAT judgment, so which is very relief giving, or we can say which is changing the course of the things, which can come to our rescue. So we'll study this judgment just now. We'll open it and study it in detail. So any assessment or claim initiated during this period is impermissible. It has been mentioned in the judgment. While several circulars have been issued by government authorities and they have reiterated this position, of enforcement actions such as search and seizure, etc., to continue during CRP or liquidation. So this is a different matter because search seizure. So definitely for documents related to corporate debtor, they may come and obtain the documents by means of search and seizure, and simultaneously they conduct the search and seizure in the premises of the concerned promoters, directors, or the officials of the companies, etc. So that is a different topic which we cannot say that it is barred. So definitely they can do. So then strict adherence to the moratorium is essential to uphold the intent. So which comes in the way of this assessment proceedings, this enclave judgment. So strict adherence is essential to uphold the intent and integrity, because in any case, as per law, the claim has to be on the commencement date of the processes. So how can they, by that means also, that way also, if we think, so how can they assess it later on and give their, revise their claim or submit their claim based on the assessment during the process? So that
Sir, can I ask one question, sir?
शांतनु जी, डेफिनेटली वेलकम. आपका तो हम स्वागत करते हैं, बट बेसिकली मैं वैसे चाहूंगा कि हम क्वेश्चन सारे एंड में ले, बट ये वाला आप
ठीक है.
सोच लिया, आप ले लीजिए. नहीं, ये लेते
नहीं, मैं ये पूछ रहा था, सिंस यू आर ऑल्सो एक्सपीरियंस इन सो मेनी केसेस. अभी हो क्या रहा है कि पुराने पुराने केसेस में इनकम टैक्स वाले पर्टिकुलरली बहुत सारा असेसमेंट्स ओपन कर रहे हैं, शोकॉज नोटिस दे रहे हैं, अपीयर होने को बोल रहे हैं. तो इसमें आपके हिसाब से क्या स्टैंड लेना चाहिए
सर
एज ए?
उसी को डिस्कस कर रहे हैं. वी कैन टेक द क्यू फ्रॉम दिस जजमेंट ऑफ एनक्लेव, और
ये तो अभी आया ये तो अभी आया.
तो अब लेनी है ना सर, स्टैंड तो पहले में थोड़ी, अब जाके अब लेंगे. आगे से ये स्टैंड ले सकते हैं हम कि साहब ये देखो, हमारे पास ये जजमेंट है और अभी तक सुप्रीम कोर्ट से कुछ नहीं हुआ है इसका, सो आप ये असेसमेंट नहीं कर सकते मॉरिटोरियम में. सो उसके बेस पे हम एनसीएलटीज में भी वो जाते हैं, तो वो विल सी कि जो भी होगा, यही कह सकते हैं. अभी अभी डिस्कस करते हैं एक बार
जी
एंड,
जी जी.
क्योंकि आपके साथ तो मजा आएगा सर डिस्कशन का. आपके साथ मेरी लिंक्डइन पे तो डेली कुछ ना कुछ होता ही, आपका जरूर व्यूज आते ही हैं. एंड डेफिनेटली
जी जी जी
नॉलेजेबल पर्सन, विल डिस्कस.
जी सर, थैंक यू.
या डेफिनेटली. सो बस एक सेकंड, कहाँ थे, पीछे चलना, जस्ट अ मोमेंट. वो क्या था? स्ट्रिक्ट एडहेरेंस, integrity, that is ensure actions whether are consistent with. चलो ठीक है, next. So these are the effects of this case where EPFO challenged the non-admission of PF dues during CRP of two corporate debtors. EPFO initiated assessment and recovery actions under EPF Act. After the CRP had commenced and moratorium had been imposed, RP rejected EPFO's claims and the COC approved the plans already sanctioned. Approved COC approved resolution plans had already been sanctioned. EPFO approached NCLT, which dismissed the claims. EPFO then appealed to NCLAT. Again. So key issues were that moratorium is there, which bars, does it bar? So this was the question before NCLAT. Does the moratorium bar assessment proceedings by EPFO? Can PF files claims filed after approval of the plan be admitted? Then does priority of statutory dues override IBC procedural constraints? So key rulings which they say moratorium bars assessment proceedings. This has been ruled in this judgment. Citing section 14(1), the NCLAT ruled that once the CRP is underway, all proceedings against corporate debtor are frozen, which includes the assessment. Any assessment or claim initiating during this period is impermissible as per NCLAT. And priority cannot override the process. It has also been held that yes, EPFO also needs to comply the IBC timelines. It's not that they have a priority under section 36, so they can submit the claim as per their own whims and fancies. So they have to adhere to the IBC timelines. And since claims were filed late, both post moratorium and post plan approval, they are not maintainable. So basically, this is a very key ruling. And आगे चलना. So accordingly, they dismissed the NCLAT has dismissed the appeal of EPFO, and NCLT's decision of rejecting the EPFO claims in both the matters has been upheld, affirming that they were invalid due to procedural non-compliance. And NCLAT has also held regarding moratorium that yes, it bars assessment, not admissible. After plan is sanctioned, the claims are not admissible, and statutory priority versus procedure priority cannot override. So we'll just take up the judgment. खोलना जरा judgment खोल देना, वो better है. आगे है. या एक बार judgment खोल देना. Just 1 minute. Yeah. So this is a judgment. So in the matter of EPFO versus Sanjay Lalit, RP of Apollo, and that other one. So Shri Ashok Bhushan, chairperson. So these two appeals raising common questions of facts and laws. This has been filed challenging the order of NCLT. So and so has been rejected. Aage chalo. Yeah. So they say the CRP against CD so and so commenced under AAA appellant EPFO. Someone was issued at 7A with the copy on so and so dates, and on so and so someone again were issued, and the claim of ITNA was submitted before IRP, and so RP replied claim cannot be considered as the plan has been approved, and filed appellant filed an IA. The adjudicating authority also heard it, and adjudicate noted that the order is dated after the plan approval, and it was held that IBC is a time bound and approval of plan has been done. So therefore, they rejected the IA. So appeal says the other one also similar grounds. नीचे आ जाओ, कोई बात नहीं. Yes, let's come down. Yeah. So इसमें थोड़ा सा पढ़ लेते हैं. हाँ, ये so appellant submitted that despite imposition of moratorium under 14, this continued the assessment. It is submitted that moratorium does not prevent proceedings under 7A so and so. And learned counsel for appellant has relied on judgments of Supreme Court and so to support this submission that moratorium under section so and so do not bar determination of quantum of dues of taxes and other liability, and the embargo is only against its enforcement. It is submitted that proceedings under 7A, the establishment delayed to give its reply, and it was the CD who is to blame for delays. The CD has no point in time in the 7A has raised objection to inquiry proceeding and took time to produce the records, assessment so and so by rejection of application. Application filed whether the prejudice has been caused since its claims have not been accepted. PF dues inclusive of damages are excluded from the liquidation estate. The order rejecting the claim is in contravention of the law into TFCI versus Rainbow Paper, where it was held that no provisions of EPFO MP is not in conflict with IBC. The priority of dues against order, the learned counsel for respondents submits that claim was filed by appellant before the plan approval, and the assessment proceedings were carried out, and final order was passed during CRP. When assessment order has been passed, it is bad in law. No claim can be admitted in CRP. Learned counsel also gave a reference of Sundaresh Bhatt submitted post approval of the plan. The claims were filed subsequent to and orders were made subsequent to imposition of moratorium. Hence, the said claims cannot. We have considered the submission now and pursued the records from the submission of counsel for the parties. Following issues arise: whether after imposition of moratorium under section 14 of IBC assessment proceedings can be carried out, and वो हम general में लेते हैं assessment proceedings. It is one and the same thing. Assessment means assessment. Basis of whether on basis of assessment. Whether any claim on basis of assessment subsequent to imposition of moratorium can be admitted, whether claims which were filed by the appellant subsequent to the approval of plan could have been admitted. Questions 1 and या हो गया, अरे वापस राइट लेके
नहीं बट ठीक है,
नहीं, थोड़ा वापस ऊपर चलो ना, हाँ, और ऊपर और या so they say moratorium was imposed which says कि so and so, चलो इसको पूरा पढ़ने की जरूरत नहीं. Honorable Supreme Court had the occasion to consider in Rajinder Kumar Bhutta versus Maharashtra Housing held that after imposition of moratorium, a statutory freeze takes place. So this is the judgment. There is no doubt whatsoever. The Supreme Court judgment. Important functions relating to repair and construction of buildings given to Mahada. Equally, there is no doubt that a given set of the board may, on such terms and conditions, and with the prior approval of the authority, hand over execution of any housing scheme, so and so, and section what they say is to elevate the purpose. They say very good. This is for the very good reason that when a moratorium under 14 of the code, the idea is that to elevate corporate sickness, alleviate a statutory status quo is pronounced under 14 and prejudice so that the insolvency resolution process may proceed unhindered by any obstacles that would otherwise be caused and that are dealt with by section 14. The statutory freeze has thus been made is unlike its predecessor in the SICA, only a limited one, which is expressly limited to 31(3) of the code. To the date of admission of insolvency petition up to the date that the adjudicating authority either allows a plan to come into effect or states that the corporate debtor must go into liquidation. For this temporary period, at least all the things referred to under 14 must be strictly observed so that CD may finally be put back to the on its foot, albeit with a new management. So in P. Maharaj, the Supreme Court has held that interpret the section proceedings. Supreme Court has also interpreted the expression proceedings as were referred in section 14, which says that in appeal before us cannot be said to throw any light on correct position in law. However, para 8.2 is important in that the objector is that section 14 to see that there is no depletion in the corporate assets and maximizing the value, continued operations of the business to allow breathing space to organize new management, its affairs, and which also include workmen, etc. in Swiss ribbon. Hence, the states the reason for section so and so. It can thus be seen that prima focus on legislation to ensure revival and continuation of CD by protecting the CD from its own management and from a corporate death by liquidation. The code is thus a beneficial legislation which puts the CD back on its foot, not being a mere recovery legislation. The interests of the corporate debtor have therefore been bifurcated and separated from that of its promoters, etc. Thus, the resolution process is not adversarial to the CD but protective of interest. The moratorium under 14 is in interest of CD itself by preserving the assets during the timelines which the resolution process is to take place again protect the corporate debtors assets from further dilution and also protects all its creditors and workers by seeing that the resolution process goes through as fast as possible so that another management can and as per its entrepreneur skills revive the CD. The plain reading here the court says plain reading under section 14 indicates that expression suit or proceedings against the CD have been used. The word proceeding is not qualified so as to confine it to proceedings before Supreme Court or civil court only. The proceedings which have the effect on the assets of CD are all covered in the expression proceeding. The question is to be answered as to whether the moratorium has been imposed. It was open for EPFO to proceed with assessment. The learned counsel state that during moratorium proceeding, no recovery proceeding. However, submissions of counsel that for the appellant is that assessment proceedings on the CD may continue. Hence, the orders of assessment passed were fully permissible and the claim based on such proceedings were to be admitted in the CRP. Learned counsel for appellant placed reliance on so and so in above case, Deshpande case, which says that in above case, the Supreme Court had the occasion to consider the provision 446 in context of reassessment proceedings under 148 and section 446, which became for consideration for Supreme Court, has been extracted in paragraph 4, which says, this is this, chalo iske aage, yeah, proceedings, etc. The words used in 446 is no suit or other legal proceeding except by leave. The Supreme Court dwell upon the expression legal proceeding, and Supreme Court in above case considers the assessment proceeding qua winding up proceeding under the Companies Act. So they say it is a proceeding under winding up. So assessment is a proceeding. Supreme Court has held in this case. So the Supreme Court has made the following observation that already reproceeded from the judgment of Federal Court in Shakuntala case. It may point out that decision of court winding up assures pro rata distribution and presidency insolvency laws. Aage chalo. So the respondent company was directed to a liquidator assessment. The respondent was assessed to tax amounting to itna. A claim was made and allowed as an ordinary claim and certified in April 52. The liquidator declared a dividend of so and so and paid a sum of itna to the department, leaving a balance of itna. Department had made a advance tax so and so become refundable income tax. Thereafter, the petition under 226 was filed to set aside the orders of income tax, mainly on the ground that demand being adjudged certified came to have all incidents and characters of an unsecured debt. It was therefore governed by the provision. In the appeal, it was contended on behalf of the appellant to gave section 49 gave to set off refundable amount. The income tax was the effect of 228. आगे चलो थोड़ा सा इसको पूरा नहीं करने की जरूरत. The Honorable Supreme Court held that Company Court cannot be invested with powers of income tax officer, and the Company Court, which is binding, cannot carry on assessment under the hence it was held that assessment proceedings are not covered under 44 the purpose. One year cannot deal with income. There can be no opinion forwarded. There is marked difference between expressions 14 and IBC section 446 use other legal proceedings, while 14 says proceedings. So fine. So this is the difference in view of the law laid down by the Supreme Court. That no proceeding can continue after imposition, which has the effect of depleting the assets of the so and so. Now we come to the judgment in Suresh Bhatt. In the above case, Supreme Court has IBC for Customs Act. In the above case, CRP commencement so and so, and 5 different notices. The claim was filed by the Customs Authority before the liquidator. The Supreme Court is a question which essentially came for consideration before Supreme Court was whether any demand notice can be issued demanding customs due during the after the initiation of CRP. So the court said, so here it was regarding the recovery proceedings. Yeah, definitely it is there. So recovery proceedings definitely are barred. So aage chalo. After studying all this, so what the court says, let us come to that. है ना? नीचे आ जाओ.
38.
Yeah, 38. We may note that IBC, being a more recent statute, clearly overrides the Customs Act. This is clearly made out by reading of 142 with a course provision would have first charge on assets. Custom would have first charge on assets, except with respect to cases under section 529A of Companies Act or recovery of debts and bankruptcy act and securitization reinforcement and IBC. So it is specifically provided. Accordingly, such an exception created by Customs duly acknowledged under 238 of the IBC. Additionally, we may note that 238 clearly overrides provision which are inconsistent with IBC. 238 provides as under the anclet while playing down the effect of section 142A and section 238 has held that Custom Act is a complete code. No person can seek removal of goods without paying custom duty. Anclet relies on judgment of so and so, so and so. There is some other case. From the above, it may be noted Custom and IBC have their own spheres. In case of any conflict, IBC overrides the Custom Act. In present context, this court has ascertained whether there is a conflict in operation of 2 different statutes. As the first effort, this court is mandated to read the 2 legislation. At the cost of repetition, we may note that the demand notice issued by the respondent are plainly in the teeth of section 14. So this was regarding demand notices. ठीक है, छोड़ दो ये वाला केस तो हो गया. So the Honorable Supreme Court also similarly, took that stand that yes, demand notice cannot be issued. The recovery proceeding cannot continue. ये वाला तो दिखा दो इसके लिए कौन सा है, ये भी कस्टम का ही है। देश पांडे सेम, हाँ ठीक है, रिकवरी प्रोसीडिंग है ये भी। सो लीव इट, आगे चलते हैं। लेट अस कम टू दिस एनक्लेव्स फाइंडिंग। या आगे आओ, या on the basis of our discussion following are our conclusions. So they have given the conclusion. Achha, this is also the court conclusion. The Supreme Court said once the moratorium is imposed, as the case में the respondent authority has only limited jurisdiction. These are other matter. No, इसको सुंदरेश भट्ट में ये कहा demand notice was issued subsequent and that was not the case assessment carried out. Hence applicability of 33 found to be there in paragraph 46 of the judgment as noted above. It is well settled that a judgment of the court has to be read in the context of the ratio. It is well settled that ratio of judgment cannot be read as statute and the so imposition of moratorium. It was open for EPFO to proceed with assessment to conclude the. So in the present case, admittedly, assessment has been completed after initiation of moratorium. We thus are of the view that once the order of liquidation is passed, moratorium under 14 comes to an end and moratorium under 33(5) is differently worded, comes into play. 33(5) ये भी कुछ पिछला वो दे रहे हैं।
इसी है सर।
The expression uses suit or other legal proceeding which occurs in 446. Thus, bar is only against suit or legal proceeding, no bar in the proceeding. Thus, after the liquidation, it is open to carry on assessment. 33(5) cannot be held to apply in assessment period. However, while looking to the expression used in 14(1), same thing, yeah. So, as was held in other matter or by the Supreme Court, ऊपर, हाँ, यही. However, while looking into the expression used in 14(1), assessment proceedings before the EPFO cannot be continued after initiation. The only difference which I could see is that in 14 the word uses proceeding and in 33(5) the word uses legal proceedings. And also institution and continuation, that is different thing. So basically, yeah, institution is also one of the things, but mainly because that legal proceeding means the legal proceeding they are taken in the legal sense, and proceedings include the assessment. So therefore, enclave has said the assessment proceedings cannot continue after initiation of CRP. So in view of the above order, we answer question numbers 1 and 2 in the following manner. We hold that after initiation of moratorium under section 14, no assessment proceedings can be continued by the EPFO. If after an order of liquidation is passed under 33(5), that does not prohibit initiation or continuation of assessment proceeding. No claim on the basis of assessment carried out during the moratorium period, which is prohibited under section 14, can be pressed on the CIRP. So question number 3 is regarding that claims filed later, उसको छोड़ देते हैं. Even या चलो इसको भी थोड़ा सा पढ़ लेते हैं यार. So it is admitted fact that claims were filed by the appellant subsequent to the approval of plan by the COC. The adjudicating authority has relied on the judgment in the matter of RPS Infrastructure versus Makul Kumar, decided on 11/9/23, which judgment squarely applies to the present case. More so when the claim on the basis of such assessment which has been made subsequent to initiation of moratorium is hit by section 14. We are of the view that no such claim can be admitted. So any claim based on such an assessment can also not be admitted as per this judgment. So the assessment is barred as per this judgment in the CRP, during CRP, and also the claim based on this judgment can also not be considered. So question number 3 is answered accordingly. In view of the foregoing, we do not find an error in the order of impugned in the present appeals passed by adjudicating authority. In the result, both the appeals are dismissed pending IAs, if any, are also disposed of. There shall be no order to come. So this is a very beautiful judgment regarding assessments. For the first, I think, clear judgment that during CRP, at least we can take the shelter of the judgment, and we can ask them not that judgment assessment proceedings cannot be continued, and whatever claim is there. And I did in one of my matter, we admitted the claim of EPFO as of the date of CRP commencement, and they have not challenged it. They have not challenged in Francona. Yeah, they have not challenged it. So there was, while during CRP, the earlier claim, which was 20 lakhs at the time of initiation of the insolvency commencement, and it was 20 lakhs, but during CRP, they did the assessment based on some balance sheets and without asking from material from us, and they filed a claim of 3 crores, 3 crores, which I rejected. So this 3 crores claim, but they have not gone further into any appeal. So plan has been implemented in any case. So now appeal time has also gone in that matter. So here we have already read it. Yes, so this para. So we'll try to give a practical example also in of what happens, what they are doing. You know, they sent us an offer notice in Dehradun Highway. So the income tax department has sent this notice during liquidation, that show cause notice on imposition of penalty under section 271. So they have sent it to the liquidator of so and so, and they say current status and final liquidation order and strike off whatever you have done. So on the basis it is observed company is still under liquidation, no dissolution has not happened. So further official liquidator has stated that the distribution of assets has also not been has been done. That the distribution under however the relevant order for distribution has not been provided. Neither reply. So in this connection, reliance is placed on the decision of Sundaresh Bhatt. So and so. Reliance is also placed on unclad order and some matter. And in view of the above facts, the keeping reliance, you are hereby show cause as to why assessee company shall not be treated as assessee in default, and penalty proceedings under 271 shall be completed. In the interest of, you are given final opportunity to explain about this. So this they gave this notice. So I'm just showing you that how we responded to them, and after that we have not received any further anything further in this matter. So they probably have accepted it, our submission. So we said that okay, fine. So that the company has not. So this notice, actually what happened is, so the company before CRP commencement, they in 2014-15 itself did not deposit TDS, for which now they are levying a penalty. So they are now in liquidation, they are levying a penalty for not having deposited the TDS. So we said that Honorable NCLT so and so in 2020 have appointed me as RP, and ICD insolvency was a resolution process was commenced, and the Honorable NCLT initiated liquidation in 2023 and appointed undersigned as liquidator. So facts are that while so and so order liquidation, and while this order liquidator was appointed, and 33(5) says that subject to section 52, when a liquidation order has been passed, no suit or other legal proceeding shall be instituted by or against the corporate debtor, provided that a suit or other legal proceeding may be instituted by the liquidator on behalf of corporate debtor with prior approval. So that way I said that this is a legal proceeding, definitely. So I submitted that way, that under 33(5) it is barred. However, pursuant to above, undersigned in terms of regulation 12 of liquidation regulation made a public announcement for claims also were invited, and we have received a claim for 32 crores from your office regarding the same matter which they are talking about, and the claim was admitted also for that effect. So for 53 provides a waterfall. So we are distributing as per the waterfall, wherein you stand at 53(1)(e). Aage chalo. In view of the above, it is clear that undersigned is duty bound to distribute the proceeds so and so, and it is pertinent that 238 of the provisions also I said that in so and so matter it was held that yes, these provisions override other laws, and even it was against the income tax department itself. So then further the amount realized from liquidation estate has been already distributed as per section 53, and there are no funds remaining in the bank account of the corporate debtor. Further, the liquidator is in the process of filing dissolution of the company. In view of this legal position, it is submitted that post or provide them any amounts. So the caption proceedings are illegal and shall be dropped. So this was the contention, and based on such a contention itself, I'll show you very interesting order which I received from Supreme Court. So I'll show you that order. आगे आएगा. So I will show you that order also, wherein in Moser Bear matter, I have received an order from Supreme Court based on these kinds of contentions regarding the amount left during liquidation, and this judgment of Supreme Court has been accepted by all, including the ITAT and the Chief Commissioner appeals, and also High Court. So all have accepted, and the matters were, I think, around 50-60 matters of income tax were closed, and even last week also something was filed by income tax in Supreme Court, which was dismissed. Yeah. So now treatment of claims again. So these all we have already said. दोबारा तो नहीं आ गया? Yeah, seems discussed हो चुका है. Yes, this has been discussed. So I will show you the provisions of section 30 subsection 2. हाँ वो ले जाओ कि how to what are the provisions during पीछे क्यों नहीं करते हैं? गड़बड़ है. इसको शॉर्ट पे So basically, so now this point is to treat the what treatment is given in the provisions of law for addressing the issue of statutory dues in the resolution plan. So basically, in the resolution plan, what they say is there is a provision in 30 subsection 2, which they say that operational creditors shall receive at least the liquidation value what they must have received during liquidation, and also they would have received as per the plan distribution in priority waterfall, as per the priority given in waterfall mechanism of section 53. So 30 subsection 2 also mandates the RP to examine the plan and to confirm that it should the amount these all amounts. So RP has to see that these things are taken care of in the plan. Then moreover, yes. So moreover, regulation 38 says that it is a mandatory content that the operational creditors shall have priority over financial creditors. So in view of this, the tax liability has to be treated in the given the treatment as per these regulations and these provisions of section 30 subsection 2 as well as regulation 38. So these are to be abided. And moreover, what is happening is, though section 31 says there is a binding effect of the treatment given to tax liability as per the plan. So specifically it says if the adjudicating authority is satisfied that the plan approved by committee meets the requirement, it shall by order approve the plan which shall be binding on the corporate debtor, its employees, members, creditors, including central government, state government, or local authority. So who are basically the beneficiaries of tax dues. So to whom a debt is due in respect of payment is due, such authorities to whom statutory dues are owed, guarantor. So specifically it is mentioned that it is due, but what we face is even despite of all this, despite of all these provisions, these authorities keep on issuing notices even after the plan approval. They keep on initiating recovery proceedings and assessment proceedings, and the attachments and pasting of notices. What all, they keep on doing each and everything, even post these kinds of this thing. What we do in our cases to address this issue, practically I'm telling you, I all generally whatever is provided in the resolution plan, we prepare a demand draft, and along with the request letter for the authorities, we submit it personally in their office, and also seek a no due certificate along with that payment from this authority, that you kindly issue us a no due certificate, so that in terms of these provisions of the that provisions of IBC, as well as the Ghanshyam Mishra judgment of Supreme Court, which says clean slate, all the liabilities are extinguished. So giving reference of that, we seek the no due certificate from the authority, these authorities, along with the payment to be made under the plan. So this thing can come to a rescue, to some extent, that when you get it received personally, and also try to obtain, though they generally don't give it, but at least we have a acknowledged copy of the payment having been made, so which we can produce at the time, and along with such a letter stating these provisions and the Ghanshyam Mishra judgment. So this can come to the rescue at the time of any proceedings initiated upon the RA. So the SRA can, have what we can say, some kind of recuse that to come out of these issues which he faces, and which diminish the value of the resolution plans, and which due to which we are not getting that value in these processes. Yeah, आगे चलो. See section 53, yeah, binding. So 53 1E, so they come into this. We have already discussed. Yeah. So government dues come under 53 for 1E. Yeah, fifth in the priority. So Supreme Court, what has happened is, so in this rainbow papers judgment has taken a different stand. So wherein a new set of issue has arisen. Though we'll come to that, how it is being addressed of late. But what has happened in rainbow papers? Firstly, let us discuss this. So in rainbow papers, the dispute is that Gujarat VAT, they filed their claim for VAT dues, and RP rejected the claim, their VAT claim, classifying as operational debt. So basically, they filed as a secured creditor, but RP treated them as an operational debt with no security interest, and treated under 53 waterfall, 53 1E. And VAT department challenged that they claimed that they are statutory creditor or secured creditor, since there is a statutory charge under Gujarat VAT 2003. So claiming that, they filed an application. So the legal question was that, does a government authority like VAT hold secured creditor status if the applicable laws create a statutory charge? Can statutory dues with a statutory charge override the waterfall mechanism under 53 of IBC? These were the two questions to be addressed. So then third was that government authority like VAT, does they hold a secure creditor status if applicable law creates that statutory charge? And then can statutory dues with the statutory charge override the waterfall mechanism? Fine. So similar, I think. Yeah. So Honorable Supreme Court's findings are that government dues, as per section 30, subsection 3, these the secured creditor have been defined like this, that including the creditors holding security interest created by operation of law. So then section 48 creates that statutory charge over the property of the dealer for unpaid VAT. Court concluded that statutory dues such as VAT backed by statutory first charge qualify as secured debt under IBC. So this was the holding which has changed the scenario a lot. We are facing more litigations now from government departments. And then GVAT section 48 is like this, notwithstanding anything to the contrary in any law for the time being in force. So this is the main line, which has played the havoc, we can say, because in other laws, generally it is said subject to provisions of IBC or subject to any other law having overriding effect. But here it is notwithstanding anything contrary. So notwithstanding anything contrary, they say any amount payable by the dealer or any person of tax, interest or penalty for which he is liable created under the state laws. The court distinguished between general unsecured statutory dues and statutory dues secured by law creating a charge. So court's view was that statutory charges under GVAT must be recognized within the plan as secured creditors. Otherwise, a plan is contrary to law and liable to be invalidated. So practical implication is that, after Rainbow Papers, they say dues with statutory charge treated as a secured debt enjoying priority, finality of plans, increased risk of post-approval challenges. So earlier there was a certainty, but now, there is a risk that after the even approval of the plan, there may be challenges which are happening also. Compliance for IPs and RPs that we have to review and incorporate the statutory charge claims. But however, the things we'll discuss later are again changing. The scenarios are changing due to the amendments and all. So proposed. So we'll discuss that. So criticism and counterpoints. Investor concern is that it undermines the certainty and finality under IBC. Overlap with the IBC 238, which creates a legal fiction between central and state laws. Operational debt ambiguity expands interpretation of secured creditor beyond financial institution, complicating the resolution process. The relevant paras 31 to 37 and 54 onwards. These two are the whereas 31 to 37 discuss the statutory charge thing and secured creditor definition, and 54 onwards the overriding effect versus vis-a-vis statutory dues has been discussed. Here, what stand I have taken, even despite this, I did not accept the claim in one of my matters as a secured creditor. GVAT claim itself, GVAT claims I have not admitted as a secured creditor, and they are in NCLAT. They have challenged the resolution plan in NCLAT, stating that yes, RP has not accepted. So my contention, NCLAT asked me, are you not aware of Rainbow judgment? So my contention there is, sir, I do recognize, but there is a provision under section 53(1)(e), which is a specific provision for government dues. And when there is a specific provision for any dues, so it cannot be, there is no need of any interpretation to bring it under secured creditor. So section 53(1)(e) covers both the secured and unsecured government dues. So it is a provision for all the government dues, not only for the unsecured government dues, because when the provision is specific for this this item only, which is government dues. So, and also then I have taken the support of Pashchimanchal judgment, which we are just going to discuss. So basically discussing all this, now the matter is going on. Even right now it is under adjudication. So while now we have new situations, we'll discuss that also. So Pashchimanchal, what it has said is, in this case, they say that this state electricity department, they attach the assets of this company, Raman Ispat, claiming statutory charge and insisting its dues to be recovered outside IBC liquidation hierarchy. Question is, does such statutory attachment under Electricity Act overrides the waterfall distribution regime under IBC during liquidation? Yeah. So IBC overrides the Electricity Act 238. Successfully, it has been held by the Supreme Court that 238 IBC has overriding effect even over non-obstant clauses in Electricity Act 2003. Supreme Court has reaffirmed that IBC overrides the Electricity Act to the extent it conflicts with waterfall mechanism, citing innovative industries precedent. IBC's 53 distribution order must be adhered to liquidation cost, workman dues, secured creditor, unsecured, government dues. So electricity dues do not receive priority as government dues are placed much lower than secured creditors, that is as per section 53(1)(e). So similar view has been taken as a stand I was telling you. So in a Paschimachal, that 53(1)(e) is a specific provision which is there for the government dues. So no need to interpret it in the secured creditors. Then rainbow papers ki distinction, SC confined the rainbow papers ruling to its facts, tax dues in resolution context, and distinguish it as limited to resolution, not liquidation phase. So Paschimachal is for liquidation, while that, but the logic can be applied because in resolution process also, there is section 30 subsection 4, which says that the creditors have to see that the distribution is as per the priority in the waterfall under section 53. So there also resolution dues have to be distributed as per section 53 only and not beyond that. So therefore, even for the resolution process, we can take this shelter of I have taken. So let's see what NCLAT says. So this is my understanding. So now Paschimachal, this is the para 49 where the Supreme Court says that the provision had not been averted to or extracted in the judgment, and furthermore rainbow papers was in context of resolution and not during liquidation. But however, as I told you, even during resolution process 53 is applicable because as per section 30 subsection 4, the resolution proceeds are also to be distributed as per section 53 only. So section 53 as held earlier enacts the waterfall mechanism providing hierarchy or priority of claims of various classes. The careful design of 53 allocates amounts payable to secured creditor and workman at second place and after the cost and expenses payable to the liquidator. However, the dues payable to government are placed much below those of secured creditors and even unsecured and operational creditors. This design was either not brought to the notice of the court in rainbow papers or was missed altogether. In any event, the judgment has not taken note of the provisions of IBC which treat the dues payable to secured creditors at a higher footing than dues payable to center or the state government. So basically, as I have told you, 53(1)(e) is there. So government dues have a specific provision even if they are secured or unsecured. So they will be covered under 53(1)(e). This should be the stand. So we'll see that what NCLAT says does in my matter in this regards. So also further the Supreme Court judgment says that Gujarat VAT no doubt create a charge in respect of amounts due or payable. It would be possible to hold in absence of a specific enumeration of government dues as in 53(1)(e) that the state is to be treated as a secured creditor. However, the separate and distinct treatments of amounts payable to secured creditor on the one hand and dues payable to government on the other clearly signifies Parliament's intention to create the latter differently. And in the present case, having lower priority, as noticed earlier, this intention is also evident from the reading of preamble to the Act itself. So, Paschimachal is a later judgment, shall prevail. So, definitely that's what I have taken the stand. So, we'll see. Again. Later, very recently, there is this one judgment, which is very nice judgment. So, we'll go through this judgment in detail. This is coming to our support a lot, This is only 2 months back, 2-3 months back, 27th March 25. in JSW versus Pratiksha Thakur Haritwal matter, Supreme Court judgment that contempt of the court has been proceedings have been initiated against the government authorities by Supreme Court for initiating the proceedings and despite of Ghanshyam Mishra case. So here I'll read out. So the case facts are that contempt petition was filed by GSW and the successful resolution applicant in the CRP of Bonnet Ispat. After the plan was approved, based on Ghanshyam Mishra judgment, state tax authorities issued fresh demand notices for taxes and levies predating the approval. So JSW claimed it of Ghanshyam Mishra did issuing tax notices post resolution plan approval for CRP period amount to contempt of the Supreme Court, because as I enumerated earlier, Ghanshyam Mishra is that all liabilities as on prior to the date of approval of the plan stands extinguished. So this is in clear terms that all the liabilities are extinguished while they have cleverly issued fresh demand notices for earlier liabilities. So they are playing over smart. So therefore this contempt petition. So obligation of the government authorities, they have taken that can government agencies invoke statutory laws to resurrect claims that were extinguished by a binding resolution plan. So they say, okay, once they have been extinguished, fine. Now it is again raised fresh. So these are new claims. So playing over smart, to bypass the judgment. So judgment of the court says that approved plan have finality. The court reaffirmed that claims not included in the plan are extinguished and the approved plan is binding on all, including government authorities. Any steps taken against such claims are impermissible and ineffective. Demand notices were illegal, which were quashed. The court held that the demand notices issued by tax authorities were illegal as they have violated the finality of the plan. All related proceedings and notices were quashed accordingly. Contempt found, but no punishment. So, court has established that yes, there is a contempt of Ghanshyam Mishra. However, although the court found the actions contemptuous, it accepted unconditional apology tendered by the tax authorities. So, I have sent in my matters, all my 12 cases, which were 12 plans were approved during this year. I sent to the government authorities to issue the no dues based on this judgment, that you issue us a no dues certificate, else it will be a contempt, because you have to acknowledge the fact that yes, liabilities have been extinguished. We just need the confirmation in terms of the Supreme Court judgment of Ghanshyam Mishra. The tax authorities unconditionally apologized and declined to impose any penalty. They said, okay, they submitted that yes, we will not impose any penalties. The contempt petition was disposed of in terms of the final judgment. So though it was found to be contemptuous, but no punishment was given. So para 34, it says, when the law laid down by this court in the case of Ghanshyam Mishra is clear and unambiguous, and specifically when the petitioner's own case was part of the batch, which is specifically dealt with by this court, the respondents alleged contemners ought not to have proceeded further with the recovery proceedings and ought to have dropped them forthwith. The continuation of such proceedings, despite the judgment and order of this court being pointed out to their notice, is nothing but contemptuous in nature. We have therefore no hesitation in holding that the continuation of the proceedings by the authorities, even after judgment by Ghanshyam Mishra was specifically brought to their notice, is contemptuous in nature. However, we do not propose to proceed against the respondents in as much as they are entitled to benefit of doubt. In the contention of alleged contemners that the state of Chhattisgarh was not a party to writ petition or proceeding before the NCLT. no doubt that even if any stakeholder is not a party to the proceedings before NCLT, and if such stakeholder does not raise his claims before IRP or RP, the plan as approved by NCLT would still be binding on him. However, this being the one of the first cases arising out of the judgment in the Ghanshyam Mishra, we do not propose to take any stern action against the contemners. So if we have any second case, we can now go, and this is not the first case, sir. So this is the second case, so we can get, some relief. In any case, the respondents contemners have tendered their unconditional apology. So impact is that reinforcement of clean state doctrine and reaffirmed that no statutory authority may re-litigate or resurrect extinguished claims post plan approval. Judicial authority is respected, but the court may show mercy on sincere apologies here. Accepting the apologies spared the punishment despite contempt filing. The judgment bolsters confidence in finality and enforceability of CRP resolution plan under IBC, especially for the investors and resolution applicants. So the key extracts are the Ghanshyam Mishra follow through. Claims not included within approved CRP plan stand permanently extinguished. Illegality of the tax demands, demand notices issued were illegal and quashed. Contempt accepted, but no punishment. Apology accepted. Contempt petition disposed of. As I was saying regarding this, liquidation after distribution in my case of Moser Bear. So Supreme Court heard us on such an appeal by the tax authorities, wherein we have submitted, like here I'll just show you. The official liquidator has filed a report that the respondent company Moser Bear is not financially viable and is under liquidation in proceedings pending before NCLT. Even if the appellant revenue were to succeed, the official liquidator is not in a position to pay the tax amount involved in this appeal. So the court has preempted that, and I showed you in Dehradun, they are saying you have yet not dissolved, therefore our claim stands. But the court says no, if there is no benefit of this thing, even if they succeed, they will not get anything. So then they say indisputably the respondent company has gone in liquidation. The company in liquidation is not in a position to pay its dues, including taxes, etc. Moreover, tax effect in the concerned appeals is just rupees 2 crores. Taking overall view of the matter, we deem it appropriate to dispose of these appeals, leaving the question of law open to be decided in an appropriate case ordered accordingly. So they disposed of the appeals, did not accept the appeals of the tax authority, saying, and based on this, even the High Court will show you. The High Court said that the Principal Commissioner Income Tax has filed appeal so-and-so pertaining to so-and-so, briefly stated the facts. SSC has filed the return, scrutiny assessment was done, reference was made to TPO, and a assessment order was passed. Assessing officer enhanced the book profit by 4 crore 66 lakhs and towards profit so-and-so long-term capital gains aggrieved by this. Appeal filed, indexation benefit. Then ITAT dismissed the appeal and revenue and allowed the appeal of the receipt. Commissioner has invoked the jurisdiction of this court and assailed the order passed. Learned counsel for the parties have drawn attention to the order of the passed by Apex Court in Moser Bear matter, wherein the appeal filed by revenue was disposed, leaving the question of law open, as the company in question was in liquidation and not in a position to pay its outstanding dues. The order passed by Apex Court is reproduced, and so and so. Learned counsel for the revenue was directed to obtain instruction as to revenue would like to pursue the appeal. Sunil Agarwal filed a letter received where so and so, sending counsel the request for instructions. So reference is drawn, intimated to pursue. However, in case court is inclined to dispose of the appeals in the spirit of the decision of Honorable Supreme Court, wherein the matter was not considered on merits but on the ground of assessment before NCLT, it would be equitable that Honorable Court also gives directions to refunds, etc. So they say एक मिनट दिखाना. अच्छा, SC is desirous of it as such there may be a situation in case SSC gets a so further चलो ठीक है. So they are saying, see, we also have certain appeals against the revenue and wherein we are seeking refund. So they say कि then the court should also address that we should not be benefited, that the liquidator takes the refund due to those appeals and which we are in the process. So basically, and we do not get anything. So here they have sought that yes, let the court also decide that our appeals should also go. And not only that their appeals are decided, but refunds also should not be given to the company. So we have, here the High Court says, we have considered the submissions. A perusal of the order of apex court make it clear that the respondent company Moser Beer is not financially viable and in liquidation. The order also makes it clear even if the revenue were to succeed, liquidator will not be in a position. Thus, if the appellant department succeed in the appeal, there would be no fructifying effect as the respondent company which is in liquidation would not be able to discharge its debts and tax liability. The courts are already overburdened. Thus, while dealing with such matter, it has been seen whether keeping alive would serve any purpose. If such matter continues to remain on board, they would be rather blocking other deserving matters. No purpose of flogging a dead horse. We are of the view there is no purpose in keeping this matter alive. Hence, in view of the peculiar facts and circumstances, the report filed by department and order passed by apex court will dispose of the present appeal, leaving the question of law open to be decided. Pending application stands disposed. So even the High Court has disposed of. ITAT also, then CIT also. छोड़ दो. सारे थोड़ी दिखाने हैं. So now this is the basic matter, this is one of a kind matter which has come to the rescue of the resolution applicants. So because had this matter not been there, had this judgment, so there was no clear indication regarding, the extinguishment of liabilities, because the tax authorities generally used to ask us, give us a specific provision where it is mentioned that the liabilities on approval of plan will stand extinguished. So we could not specifically find out any such thing, we just used to give reference of the priority of waterfall and say that since the priority we are not even able to pay off the secured creditors, so there is no chance of you getting, so therefore your due stands extinguished. But now in this matter, this Ghanshyam Mishra, which is a real, boon for, we can say, the resolution processes, and which has clearly spelled out that all the liabilities stand extinguished. So this has come really to the rescue of the SRAs and also a great booster of resolutions. So here I will show you the background and the facts and the judgment also in this matter, which is very interesting. So in this landmark IBC case, the Supreme Court addressed whether statutory creditors, including center, state, and local authorities, are bound by a plan once approved by under Section 31(1). The plan had been approved by AA, raising questions about legal enforceability of claims not included in the plan, particularly government dues predating CRP. Legal issues and arguments. All stakeholders, including government authorities bound by the approved plan, can recovery proceedings be initiated post-approval for dues not incorporated in the plan? Is the 2019 amendment to 31(1) clarificatory or substantive? ये amendment क्या है? पहले 31(1) की amendment दिखाते हैं, है ना? 31(1) की amendment क्या है? 2019 एक बार दिखाया था. Yeah. So here, as we have read, again the question comes is,
Amendment.
Okay, this is the amendment, which says,
I-
including this, in this amendment, they have specifically included. Now, what is to be noticed here is that this amendment was specifically for this purpose only, that the plan is binding on state government, local authorities, etc. And, to whom the debt in respect of, a second, just like, need to, take it down. So whom a debt in respect of payment or dues arising out of for the time being in force such authorities to whom statutory dues are owed. So these were included in this section specifically, that the plan will be binding on these also, and provided that adjudicating authority shall, before passing approval, satisfy that the plan has a provision for fine. So this was also another amendment, but for our interest in this matter, so state governments and local authorities to whom a debt is there for payment arising under any law or whom statutory dues are owed are also covered by virtue of this amendment. So now this question was to be addressed by the Supreme Court. So let us come to that. Yeah. So now binding nature. So what Supreme Court has adjudicated is that binding nature of approved plan. So paragraph 95, they say once a plan is approved by the jury, the claims as provided in the resolution plan shall stand frozen and will be binding on the corporate creditors, including state, center or local authority. All such claims which are not part of the resolution plan shall stand extinguished. So means ki plan is binding, that is one part. 31(1). One part says plan is binding. That means whosoever claims were there, whatever they have been provided is final. Like for 100 rupees, they have been given 1 rupee is final. That is binding on them. They are to accept it. If they have been provided nil amount, so that is also there in one of my matter today itself, in NCLAT, one person has filed like this, that zero amount, how can they provide for nil amount? So court says if there is nil liquidation available, it was Justice Ashok Bhushan himself. So in my matter itself, in today's hearing, he said even if nil is an amount, so if the nil is provided, liquidation value is nil, so it's okay. So fine, operational creditors are to get. So whatever they could have got in the liquidation. So nil is also no, so you cannot say that if nothing is provided, nil is provided, that is that is violative of any provisions of law, because their contention was that plan is in contravention of law. So he says ki which laws you are talking about, which law says that nil amount cannot be provided. So if the liquidation value for operational creditors is nil, so fine. So you have been provided nil amount. So he has not issued notice till now in that appeal. So today it was being heard. So basically, so now there are three situations. One situation is plan provides an amount. So 31(1), fine. That amount is binding. They have to accept it as a full and final, full and final payment for their claim. And plan second situation is nil amount has been provided. Fine. Nil is also an amount. So if the liquidation value for operational creditors is nil, nil amount can also be provided. That will also be binding as per 31(1). Third situation, wherein the plan does not cover those claims, or the claims were not filed, anything like such a situation is there. Still, the court has said that all such claims which are not part of the resolution plan shall stand extinguished. So even those claims which are not part of the plan also stand extinguished as per this judgment. So extinguishment of pre-approval claims. Another paragraph says all the dues, including the statutory dues owed to central government, state government or local authority, if not part of the resolution plan, shall stand extinguished and no proceedings in respect of such dues could be continued. Nature of 2019 amendment. It says 2019 amendment is clarificatory and declaratory in nature and therefore will be effective from the date on which code has come into effect. So basically it is not that it will be not be applicable for pre-2019 matters. So even on those matter also, because some clarification has been given, some declaration has been made, and it is a clarification that yes, it was binding. Earlier also 31(1) says plan approved is binding on all concerned. So it is only clarifying that these people are also included, so that they should not tomorrow say that we are not a stakeholder. So all the central government, state government who have some demands from that corporate debtor, they are also, it is also binding on them, the approved plan, even though they were not part of the plan or their claim was not addressed. Hello? Yeah. So impact of this judgment is that the ruling underscores it has reinforced the clean slate doctrine. After approval of the plan, finalizes liabilities, preventing revival of pre-approved claims. Confirm that statutory dues are treated like operational debts and subject to extinguishment if not included. Ensure finality in resolution, encouraging firm confidence among resolution applicants and distressed information investment process participants. So basically, it has very nicely reinforced the clean slate doctrine, which we were talking about since beginning, that the corporate debtor has to be handed over as a clean slate to the new RA, and he should be able to write his own script on the about that process, about that corporate debtor. So it may be a success or a failure story, that is up to him, but he should be provided a clean slate to write upon. So this has been reinforced by the judgment of Ghanshyam Mishra. So key extracts are that binding nature, yes, applies to all the stakeholders, including government. The recovery of dues, not in plan, it is also not allowed. Even if the dues are not addressed in the plan, they also stand extinguished. 2000 amendment is clarificatory, therefore it applies retrospectively since the beginning of the code. There is a provision in law which also reinforces the process, the principle of clean slate, like Ghanshyam Mishra. However, not very clearly, but at least to the extent of offenses are concerned, the liability for offenses. And it says, section 32A, liability for prior offenses, notwithstanding anything to the contrary contained in any law, the liability of a corporate debtor for an offence committed prior to commencement of CRP shall cease, and the corporate debtor shall not be prosecuted for such an offence from the date of plan has been approved by the authority, if the plan results in change in management control of the corporate debtor. A promoter who was not a promoter and who was not a person to whom, in regard to whom investigation authority has reason to believe that he had abetted or conspired for commission of any offense, and filed a report, provided that if a prosecution has been instituted during CRP against such CD, it shall stand discharged from the date of approval of plan, subject to requirements of this subsection having fulfilled. So basically, it can be utilized even for non-filing of returns by the CD sometime at any time, even for non-filing of ROC returns, etc. So we are trying to use in one of our matter this 32A, to the extent that because the CD has not filed the accounts, etc. Now ROC is asking us to pay penalties, asking the RA, in fact, the RA to pay the penalties for the entire earlier periods which the returns were not filed or the documents were not filed. So we are before NCLT seeking directions for the ROC in this regards, because of this section 32A, that we cannot be, the RA cannot be the new CD under new management cannot be forced with or put on with liability for the prior offense which was committed by the erstwhile management. So we are taking shelter of this, And it says also further that no action shall be taken against the property in relation to offence committed prior to CRP. So where such property is covered in the plan approved which results in change of so and so promoter etc. For the purpose they say attachment, seizure etc. is also. However, even if this is there, still there are confusions, still despite of this having there, in this matter of JSW, what I should say, Bhushan Steel matter, though now it has been set aside, but it was set by the court because in this matter attachment was done post approval of the plan by ED. And earlier Supreme Court had clarified under 32A that this cannot be done. But now, while passing this judgment in this matter, Kalyani Co. versus this Bhushan Steel, there Supreme Court has again, said that no, 32A doesn't apply, and so some kind of confusion is there with that. But that judgment is now set aside, is being heard afresh. So therefore, it's fine. Otherwise, it was a wrong thing which was done in Bhushan Steel matter, that the ED has attached the properties post approval of the plan by even the NCLT. Post approval of the plan by NCLT, they attach the properties. So, which Supreme Court, I don't know why, but has held that yes, it was not covered under 32A. So, but that is now set aside. So, we can take the position as earlier that 32A definitely has an effect for attachment, that at least they cannot attach the properties. They cannot take any action against the properties post approval of the plan. Then in Vinergy, yeah, as I told you that here I am using so assessment order in this matter. And again, one more thing is done. Assessment order has been issued by Income Tax Department post approval of the plan. So this is the assessment order which has been issued. In June 25, a detailed profiling was carried out. It was found that SSC filed in 2014, 15, 16, 17. This happened. 23 summons were issued, and so happened. Total credits and debits of 2018-19 they are saying. So SSC has, despite these much of credit debits, prior to even this is prior to ICD, so they have not filed a return. So being a company shall so and so furnish return so and so, it is seen from the record that transactions are 148A. They are saying inquiry has been conducted. However, SSC has not responded. So on perusal, prima facie income chargeable escaped. The value of transactions above 50 lakhs qualifies it for 149 1B. Accordingly, notice was issued. Reminder show cause was issued. Aage chalo. Subsequently, hand delivery was done to the registered office at so and so. So these all notices they must have been sending, to the registered address which did not exist, which this building or even is taken over by some other people. I think bank had sold it in surfacey, under surfacey. So therefore, we were not able to receive any such notices. No reply has been submitted. Aage chalo. So, in the absence of any so and so, therefore, in exercise of power, income chargeable has escaped the prior approval of the additional commissioner, so and so has been obtained. So, they have, they say we conclude that income chargeable escaped the assessment. So, fit case for issuance of 148. So, they wanted to assess, conduct assessment. So, we gave a reply. So, after which they have not responded. So most probably they must have, because first time learnt that yes, this company is under CRP. While the authorities, they should check the IBBI site. When they find any such thing that no activity is there, they can go to the IBBI and at least have a look, they should not waste their time. They can have a look on the record that is this under CRP or liquidation. They will come to know accordingly they should issue. So we told them this. So we were appointed and so there are criteria of judgment. Ghanshyam Mishra also we have given reference of. So in another NCLAT matter also we have given this. So clean clean slate. So plan is binding and proceedings are not cannot continue or proceed. So login credentials are not available with the undersigned as the same are were not provided. In view of the same, undersigned is obliged to respond through email. So therefore, further your God office in 31.1 plan in so and so 31.1 also we have referred. 32A also we have referred. All that things we have referred to. Key issues scan income tax department in Tata Steel versus this thing deputy commissioner. So clean steel doctrine was upheld and all that. So alternate remedy rejected. So all these references we have given in view of above aforementioned provisions, judgment and facts. The assessment prior to approval of a resolution plan for a pre-CRP liability cannot be considered. This is for your information and necessary action. So after this, we have not received anything. So now regarding TDS, we'll take up this issue because it comes in very frequently that in liquidation proceeding, basically TDS deduction, by for say on sale of assets by liquidator. So this issue I have taken up in a lot of my matters. So and we got favorable, action, and we were not, either we were not, we did not get the TDS deducted from the purchaser, of the property, or we have got refund. So how we did, I'll show you some different matters. So first issue is deduction of TDS under so and so on sale of assets by liquidator is inconsistent with the provisions of 53. Is it inconsistent? Does it leads to priority of recovery of government dues, which is not allowed under IBC? So this is as far as TDS is concerned. So earlier it was about tax liability. Now on sale of asset, as you are aware, that if the property value is more than 50 lakhs, TDS is to be deducted. So for that, this thing we have taken up. So section 194(1)(a), it says about this 1%. आगे चलो Key issue, whether 1% TDS. So it is Om Prakash Agarwal and versus CIT and UPL and NCLAT judgment on the sale of immovable properties. Whether 194(1)(a) is inconsistent with IBC waterfall, can liquidator claim a refund of TDS? So these issues were addressed in this judgment, regarding the TDS. So the ruling is TDS is an advance tax and not merely procedural. TDS under 194(1) is an advance capital gains tax, not just a procedural deduction. It amounts to government dues being collected upfront, which disturbs the priority set out in section 53 of the IBC. Very nicely held that it's not only that TDS is some procedural thing, it is collection of the government dues. So which is not allowed. It is inconsistent with the IBC waterfall. Government dues, including capital gains tax, fall under 53(1)(e) and rank 5th in priority. TDS deduction gives preferential treatment to the income tax department, violating the IBC framework. Here I would like to, submit. Basically, why this thing? Because in any case, GST we are collecting on the sale, but we are not saying the same thing for that. But we are saying this thing for, TDS because 53 gives the waterfall mechanism for distribution of realization from liquidation estate. So realization of liquidation estate is the price which we get, and GST, since we collect it additionally than the price of the assets just to be deposited, there we are acting as a custodian for the government, and we are just collecting it and depositing it. So there it is not a realization from liquidation estate, but TDS is being asked from the realization out of the liquidation estate, hence prohibited, because the waterfall mechanism gives the the priorities, how the distribution is to be made of the realization from liquidation estate. That's why TDS, they say, is contraventional. It does contravene is inconsistent with the IBC waterfall. So there is 238 is there, since there is an inconsistency between 194A, 1A and 53. So later will override by virtue of 238. Then liquidator not obligated to file IT returns. There is no provision under IBC or IBBA regulation that mandates the liquidator to file income tax returns. Filing returns is a lengthy and burdensome process, not aligned with the IBC's objective of time-bound resolution. So since in liquidation we don't even need to prepare accounts of the corporate debtor, only as on the balance sheet as on the liquidation commencement date is to be prepared, which is final balance sheet of the corporate debtor. Post that, only 14 registers which are prescribed in the liquidation regulations or law are to be maintained. No other accounting is required. No balance sheet, P&L returns, etc. are required to be filed in liquidation process. So only up to the liquidation commencement date. So here they have clarified this also. Then direction to refund TDS. So since the TDS was deducted in violation of IBC provision, Income Tax Department was directed to refund the amount to liquidator. So the conclusion is that deduction of TDS during liquidation sale is inconsistent with IBC's distribution scheme. Section 194(1)(a) cannot override 53 of IBC, and such TDS deductions are impermissible. Income Tax Department must refund the TDS amount deducted during the liquidation sale. So such things happened with me in my processes. There are some examples. One is Dehradun highways. So what happened is NHAI. So what we did is we settled the matter with NHAI and during the liquidation, and received 308 crores from NHAI for termination of the road project Dehradun Haridwar highway. So this is an ERA group company. So the settlement was done and pursuant to that, we received that 308 crores. But they said this is an income for the company, so they deducted TDS out of that. So we took up, this matter. So they say kindly refer to the agreement wherein settlement amount of 307 crores was agreed, and it was also agreed that concessionaire senior lender shall indemnify NHAI from any third party, which is vendors, statutory authorities, etc. Now Joint Commissioner Income Tax wide has raised the demand. No, this is a different issue. So that is which they deducted when we gave reference of that matter of NCLAT, etc. So they refunded it. However, there is another matter, So what they did is they also deducted an amount which was an earlier recoverable amount of income tax, which claim we had admitted, 32 crores. So, which was a TDS deducted by Dehradun Highways in 2018-19, but not deposited. So they said that Joint Commissioner of Income Tax playing over smart, they raised a demand and asked them not to, because somehow they got to know, maybe through the promoter or somebody, because prosecution of promoter was going to in this matter for this recovery of this amount. So therefore he informed the tax department that there is some NHAI is making a payment to the liquidator. So you ask them to hold the amount of TDS, the recoverable amount, out of the amount being paid to the liquidator. So they held up this amount of 32 crores, saying that the authority is in advanced stage of depositing the settlement amount to the liquidator. Hence, in view demand raised by income tax, it is requested to provide your comments whether NHI needs to pay the amount to income tax directly or same shall be released by lender in consultation, liquidator in consultation with NCLT. Further, it may also be informed about applicability of deduction issued with prior approval. ये किसको लिखी है इन्होंने? They wrote to us and asking us the same question. They just were playing safe. However, we replied. Let's see. To NHI, yeah. No. Yeah. So we replied to NHI, to the CGM, in reference to your so-and-so claim of income tax. It is worthwhile to mention herein that the Honorable NCLT wide order dated 23/1/23 initiated so-and-so liquidation. Liquidator was appointed pursuant to Regulation 12 Form B, as public announcement was made, and last date was so-and-so for claim submission. Deputy Commissioner had submitted the claim, which was admitted, and as per waterfall mechanism, it is to be dealt, so which designates the priority of out of the liquidation state. And since NHI, whatever we were getting is as a out of the liquidation state, because it was a receivable amount in the books of the corporate debtor. So the receivables in the books of the corporate debtor are also, the part of liquidation state. So we are realizing out of the realizable receivables in the liquidation state. There were a receivable amount of 2000 crores, which was settled at 306 crores. As per High Court's orders, we went to High Court, and High Court, said that yes, there is a provision in the agreement that they have to pay minimum at least the whatever has been directly incurred by the corporate debtor on the project. So this cost was assessed by an independent engineer in terms of the concessionaire agreement and by orders of Delhi High Court, and then the NHI was forced to pay us, this amount which was assessed. So in the view of the provisions of code, the undersigned is duty bound to distribute the proceeds out of the sale of liquidation of assets. Thus, by submission of its claims through Deputy Commissioner, the Income Tax Authority has acknowledged that the claim filed by them and admitted by the liquidator shall be dealt as per 53. In fact, the Income Tax Authority has no authority to request NHI directly for payment of its dues. Letter issued by them is misconceived, not tenable in law, and void ab initio. It is a settled law that the dues of the creditors are settled by liquidator of the corporate debtor. In this regard, it is relevant to mention that the Honorable High Court of Jurisdiction, Hyderabad, for the state of Telangana, so and so has held. It may be noticed that in so far as the SS company in liquidation, in liquidation is concerned, 178 provides for priority in appropriation of amounts set aside by the liquidator for clearance of tax dues. However, it may be noted that liquidation could either be under different enactments. In so far as liquidation company under code is concerned, section 178 of the Act stands excluded by virtue of 178(6) in accordance with 247 of the code. Therefore, in the event of assessing companies in liquidation under the code, the income tax department is no longer claim a priority in respect of clearance of tax dues of the said company. In context of liquidation company, under provision of the code, income tax department not being secured creditor must necessarily take recourse to distribution of assets liquidation state under 53 of the code. Besides, provides the order of priority, any amount of the central government, etc., and to be received so and so in the fifth in the order of priority. Comes fifth in the order of priority thereof. So then we said that in view of the aforesaid judgment, it is evident that no one, the undersigned has no to distribute proceeds as per 53. Further clarified, NHA is not required to make any direct payment to any authority, including the income tax department, and their claims shall be dealt by the liquidator under the provisions of law. Insofar as applicability of deduction of statutory taxes such as TDS, GST are concerned, it is humbly submitted that these statutory taxes are not applicable since no service is being provided. In fact, the amount is towards settlement of outstanding receivables of Dehradun Highway project. In light of the aforementioned, NHAI may release the total amount of 306 and which was received after this response. So to income tax also we wrote, so to take caution and not play such gimmicks, So this has reference to the letter issued by your good self to the chairman of the NHAI asking for a recovery of 32 crores. Copy of letter is attached. In said letter, your good office has also evidently admitted that you have submitted a claim before the liquidator in a proper manner under the provisions of IBC. It is submitted, your claim has been admitted and will be dealt as per the provisions of IBC. Now facts contained. These facts have been given to them. आगे चलो. Then Monet Ispat order, PCIT versus Monet Ispat, all these orders which we have given there. So these judgments were shared with them. So it is important to note down here that the claim provisions of 53(1) of the code having overriding effect, the proceeds of liquidation can be distributed in order of priority in that section, and the funds receivable by CD from NHAI constitutes the liquidation proceeds in the hands of SSC, which have to be distributed as the order of priority and as per section 53(1), and out of turn payment of the same to income tax as contemplated in your letter is in breach of the waterfall mechanism specified and would be totally illegal and untenable in the law. Supreme Court has held in Khalgalkar case that income tax department secured creditors have priority over income tax. Therefore, out of turn distribution of assets to income tax in case of company under liquidation would be injustice to the rights of secured creditor and tantamount to gross illegality. Supreme Court recently in the matter of Pashchimanchal has also held that settle the waterfall under the provision that dues payable to secured creditors so and so central government come under so and so priority. Rainbow also. Even rainbow, they say careful design of 53 locates the amounts payable to secured creditor and workmen at second place after the cost and expenses. However, the dues to government are placed much below the secured creditors, even below the unsecured and operational creditors. In any event, the judgment has not taken note of provision of IBC which treat the dues payable to secured creditors at a higher footing than dues payable. So even rainbow says
rainbow so they have
अच्छा पश्चिमांचल में जो रेनबो का रेफरेंस ओके so consequently मतलब even in rainbow they have why they have given priorities because they had some charge statutory charge and not that rainbow says that government dues have a higher priority. So consequently, exercising lien or externus recovery proceeding post declaration of moratorium under provision of 14 or 33(5) of the code is wholly unsustainable, which is held in by Punjab and Haryana High Court. So, and even in Andhra Pradesh High Court, the court says that only way of tax recovery for a department is in such a case is lodging of claim before official liquidator. Therefore, even if the order of attachment छोड़ दो इसको आगे चलते हैं या so all these judgments are there ठीक है so dual claim so now we say that dual claim of outstanding income tax demand. So firstly you are asking from liquidator, secondly you are asking from NHAI. So it is a dual claim of the same amount. You are claiming from two persons the same amount, so which is not maintainable in law. So moratorium is applicable. That also we inform them. So no suit or legal proceedings. So it is submitted that law is well settled. So it can be done only 53. Yeah, आगे चलो. Financial condition of SSC does not warrant payment of tax dues. So that you will not get that. Also, I inform them that even if money is not available. So even during distribution, you will not get it. So that also we inform. Chalo. the aforesaid Supreme Court decision in the case of Moser in our respective is binding upon all quasi-judicial. So in this case, we also quoted the Supreme Court decision of Moser that if the recovery has been done, all the assets have been sold and there is nothing left for the income tax department. So there is no point in even appeal. So we actually discourage them to go for litigation also. We said that even in appeal, it is not maintainable in Supreme Court because nothing will be left for you after payment as per the waterfall. So, respondent company has, yes, ठीक है, उसी से करो. So basically, so with this, so we could prove our point, and in overall view of the above, it is respectfully submitted before your good office that continuing recovery proceeding under consideration is against the applicable legal framework. So due to moratorium also, so there were 2 points basically. One is moratorium. So this was a recovery proceeding because they were asking for recovery out of some dues from NHA, and also moratorium, and secondly breach of waterfall, and thirdly dual claim. So all these points we rose, and so income tax also did not pursue. So maybe they have themselves returned to NHI. So whatever we got our amount. So the claim of income tax department lodged with liquidator in the respect of would be looked upon, dealt with in professional manner as per legal provision, and so your good office to forthwith withdraw the letter, and failing which undersigned shall be constrained to approach NCLT for appropriate direction, including technology. Okay. So there is another matter regarding TDS, which I said another way of getting the TDS, refund, which was deducted. One is that it should not be deducted by the buyer. One is if they have deducted, what we did is somehow, though we are not supposed to file an income tax return, but if we file a return and we say that yes, no tax is payable, so refund automatically comes to us. So we filed the return and got the refund of that TDS which was deducted by the purchaser, because capital gains is not applicable. So in the return, no capital gain was there, no tax was payable. So refund automatically came back to us. That is also what I wanted to submit here. So we filed with NCLT, but and Deputy Commissioner, but time was being taken. So what we did is we filed a return. So this is also a mechanism that in case the buyer, sometimes the buyer says, I will fulfill my duty. I will not, I will have to deduct it. In many matters, it has happened that the buyer doesn't. So there is one way which we can approach the NCLT for the directions of refund to income tax. And there is second way here, with like we have done, issue appropriate directions to the respondent, which is income tax department, to refund the TDS of 72 lakhs deposited and 1.45 crore deposited out of the sale consideration, and so that the same can be distributed as per 53. So before we withdrew this later on because we got the refund by way of filing of a return. So refund was issued, see, like this. So refund issued, so this is the communication, 2 crore 54 lakhs, we got the refund. Including interest, we got the refund. So there was no requirement of any order, etc. Just by filing the return, because in any case, there is no bar also on the liquidator. There is no specific provision barring the liquidator not to file a return, income tax return. So we could file the return and get the refund again. Now, in the end, what we can see is the entire position, as we have discussed, is now getting modified to some extent, by way of this proposed bill, the bill which has been already placed in the Lok Sabha and has been referred to select committee. So if there is, if the bill passes the parliament and all, so it becomes a law. So the positions will be modified. So we will this. So this, since this is an important point or important development, we will discuss what are the proposed amendments in the law as regards tax dues are concerned. ले जाओ. So amendment is being made to section 31, where it says, where the adjudicating authority approves the resolution plan under subsection 1, unless otherwise provided in the plan, any claim against the corporate debtor and its assets or the timing prior to the date shall be extinguished. No proceedings shall be continued. Okay, so this is 31(6). New subsection is being introduced, which will say that adjudicating authority, when it approves the plan, so unless otherwise provided in the plan, any claim against the corporate debtor, its assets under any other law for the typing in force prior to the date of approval shall be extinguished. Because I said there is no provision in law, specific provision which could extinguish the claims, so the liabilities. So now they are bringing in, because what we had is, we had the Ghanshyam Mishra judgment, which was coming to the rescue, which said that yes, all the liabilities shall be extinguished, though there was no clear-cut provision in law. So now there is a provision which says that yes, the liabilities shall be extinguished, and this provision is brought in by way of a separate subsection in 31. So they say no proceeding shall be continued or instituted against the corporate debtor or its assets on the basis of such claims, including proceedings for the assessment of the claims. So they say even the proceedings, the law itself will cover that the assessment is included in the proceedings. No requirement of any kind of interpretation. The law itself says that the proceedings of assessments will be barred after plan is approved, because post approval of plan also the authorities they take it like this, that the moratorium is ended, 14 and 33(5) both. So therefore now the corporate debtor is a free person. So now we can go ahead for proceedings of assessment. So they started after the end of the moratorium. Shall affect a claim or any proceeding in respect of person who was a promoter. ये तो हमेशा है ही है. Then expression 2 says that if a person has a joint or several liability with corporate debtor of the debt before approval, and such person makes the payment for such debt after the approval, then the right of such person to be indemnified shall be extinguished. So if the promoter, generally what happens is, like I told you, in the DHPL, Dehradun Highways case, there was a prosecution going on against the promoter, because there is a several joint and several liability of the promoters also for the tax dues which remain unpaid. So the income tax department was having that prosecution, they were going on. So, but there is a provision in law that if a person makes a payment for the corporate debtor, he has the right to be indemnified. So, but by virtue of this section, that indemnification right has also been extinguished. Otherwise, what would have happened is the promoter pays, and they will seek, he will seek indemnification from the corporate debtor under the new management. So that right of indemnification is also extinguished by virtue of the amendment. There is an amendment to section 53 also, which says that debts owed to secured creditors. Explanation has been inserted in the subclause in clause B, subclause 2. So where secured creditors priority is there of payment. So here it says for removal of doubts, it is clarified that the value of the security interest relinquished by the secured creditor is less than the total debt. So, so this is regarding, what happened is sometimes there the security has diminished. The security has diminished. Still, the creditor claims itself to be a secured creditor. So they say if the security value is less than the total debt owed to the secured creditor, he shall be a secured creditor to the extent of value of the security. So only to the extent of the value of the security interest, he will remain a secured creditor, determined in such manner as may be specified for the remaining value of the of the such debt, he shall be considered to be an unsecured creditor. So whatever remains after the value, considering the value of the security interest available with him, the balance amount he will remain unsecured. It is also proposed that any amount due to the central government, central or state government, this explanation is added where it is clarified that any amount, whether or not a security interest is created to secure such amount due to the central or state government in respect of the whole or any part of the period of 2 years preceding the liquidation commencement date, shall be distributed under this subclass, and any remaining amount, whether or not a security interest is created to secure such amount due to the central or state government, shall be distributed under clause F. So in fact, they say ki if the 2 years, for 2 years period, whatever amount is there, whether security interest is not there or there, so they will be under clause E, government dues will be under clause E, and post that, if there is something remaining besides the security interest, so that will be distributed even below this. So they have already created a layer before clause under clause E. So even there is a change in the definition. So if we can open that, so or I will also say they have changed the definition of the security interest in the proposed amendments, wherein they say the security interest will be which is specifically created in favor of the institution and not the security interest created by law, by operation of law. So the security interest created by operation of a law has been altogether taken out of the purview of the secured of making him a secured creditor, the person a secured creditor. So basically, because clause 1B2 of 53 that says regarding the secured creditors who hold a security interest, but in the definition of security interest itself, they have excluded the persons having security interest by operation of law. Only the security interest which is specifically created will be counted as a security interest and for the purpose of treating them as a secured creditor. So if it is by operation of law, it has gone out of the definition of the security interest. That is a major development, and this development of this one, the clause B, subclause 2 explanation. This will also cover the charges, the priority of charges aspect, wherein we say that yes, there is a charge, some person has a charge, so how it will be taken. So basically only up to the value of the charge they are holding, of the security they are holding, that much, for that much amount they will be secured creditors. Yeah, ये तो हो ही है 31 codifies the Supreme Court rulings, closes door for statutory to revive or reassess during dues post resolution, strengthens the finality of the plan. 53 clarifies that the statutory dues will be paid whether a secured or unsecured, will be paid under 53(1)(e). The proposed amendments will avoid any ambiguity in distribution. So I think this much will suffice. So there are many more things because we have to take questions also. So we have only half an hour left. So at least this much time for such a huge, this thing. Thank you. Thank you. So yeah. So questions. Let us take it from the chat first. Yeah, yes. So questions, let us take the questions first. So questions in the chat box. So let's take these questions first in the chat box. So here they say, sir, is there, it says collate and verify the claim. Some disconnect here, don't you think that has been addressed? So collate and verify, collate is a word used in judgment, that you just collate and not adjudicate. Status of the losses in the case of a sale as a going concern. So that is addressed as per the amended provisions in Income Tax Act. Then here we have a couple of cases rejected the statutory charge on mere raising of demand unless due process is completing an attachment order of the passed by the VAT. They of course always challenge it, right? So then is
So
issue.
this is what I had submitted. So in couple of my cases, the Shantanu here, in
Yes, sir.
in couple of my cases, the VAT people, they came back, of course, much after the deadline, and they filed their claim. In one case, they filed their claim within the district also, saying that we are secured as per the rainbow paper judgment. But what I saw is that they had only raised the demand notices, and based on that, they were saying that we are secured creditor. So we took a stand, sir, that though you have only raised the demand notices, you have not completed the due process of adjudicating it and finally passing a attachment order, and which should have been done prior to the commencement of the CIRP. Since you have not done that then, you can't do that now. So hence, I will treat you as a unsecured creditor only. We admitted their claim, but not as a secured creditor. They have not challenged. In another case, we had seen the same thing, but they have gone to NCLT and challenged it. The matter is pending as usual. It will go on. So this is my experience. This is the way I have replied to VAT twice. And regarding income tax, of course, I had a lot of doubts which you have cleared, and I have also been filing the similar replies, citing various case laws and things like that. So much so I actually tell them also in writing that your claim stands extinguished as such, in liquidation, that there is nothing to be given to you. Kindly kindly mark your claim as unrecoverable. This is what I write. I do not write extinguished. With this one, I had met one principal commissioner of income tax. He only said कि तू ऐसा लिख दे. I just generally told him, ki, boss, why do you all keep on bothering? Because every time you all send a notice, I have to appear or I have to reply. It incurs cost, time. What is this? He says, no, so we are just completing our process. You reply like this. But even after I reply, they send penalty notice, everything. After some time, I stop replying altogether.
So no,
What
you
to do?
got insider information, the technical term they must be using, unrecoverable or not recoverable. So they need to
Huh.
use this, that term. So the technical term, the insider information.
No, so that's what he suggested, ki you do
Yeah.
that, because if you write extinguish, we cannot really extinguish without a court order as such. And because in my Gitanjali case, which I am handling as a liquidator, so obviously there is all PMLA attachment is already there. Besides that, what I saw that income tax has also attached all the properties. So some properties were released by ED. Then I approached income tax saying, ki, sir, you have attached the properties, all right, but since you have attached the properties, anyway, you don't enjoy any priority. And unlike the VAT Act, your this thing does not give you a priority. Even Income Tax Act per se doesn't give you a priority as such. So they said, yeah, we understand we will not get anything, but nevertheless, you get a court order. So I filed an application with NCLT. They were supposed to cooperate, saying that, okay, we have no objection in removing the attachment from the property. But the officer changed, and they are now contesting based on rainbow paper and all that. So Let us see how that plays out. Because with their claim is global, something like 13,000-14,000 crores. Now, if a 5 crore, 6 crore property is sold, that will not be able to be transferred, because generally they write to all the sub registrars कि do not transfer without our NOC. Society में भी दे देता है. So the practical problem, I'm sure, sir, you would have also faced so many.
Yes,
तो
all this comes,
यहाँ तो ये तो आता ही है. But this is what it is. Now it's actually becoming very irritating, frankly. Long after even resolution applications are filed, still they keep on raising demand notice.
Right.
Uh,
So,
it's,
yeah, thank you very much. Yeah, thank you very much, Shantanuji. Thank you, thank you. We got the opportunity to hear from you. Yeah.
My pleasure, sir. I learned a lot from you, at least on this tax replies. So I have a bunch of them today itself. So
You, you can take some cues.
I will take a liberty of copying your reply from.
Anytime. I will send you personally. I will send
Yeah, thank you. Thank you so
in
much.
text format. I'll send you all in my text format. Prashant ji karna.
Yeah.
Shantanu
Thank
sir.
you, sir. Thank you so much. Thank you so much.
Most welcome,
Yeah.
most welcome. And thank you, Shantanuji. And like him, there is one more prominent RPN, my friend, Vikram Bajaj. He is there in this. Just a moment. कहाँ चला गया? Oh, there it has gone.
Yes, sir.
हाँ जी, क्या हाल है विक्रम जी?
ये सर बताइए कैसे
मैं तो आपका मैसेज देखा तो मैं कहा यार वेरी नाइस. So Vikram ji is also there. It is my honor.
सर मैंने कहा आपका पूछे हमें तो सीआरपी कमेंसमेंट का ऑर्डर से पहले की सर्टिफाइड कॉपी से पहले ईपीएफ का नोटिस आ जाता है इंफॉर्मेशन देने के लिए.
अब वही मैं आपका वाले पढ़ रहा हूँ. आपने लिखा है, एक्चुअली आपकी थोड़ी वॉइस कट रही है, but you have written is what should be the response to request for information and assessment proceedings by EPFO or IT and fresh claims based on proceedings information provided during CRP. So basically यही जो आपका assessment proceeding के लिए तो I have now we have an unclear judgment of this year only, that 3rd January judgment. So we can tell them that yes, assessments are barred, and also the intent of law, the forthcoming amendments in IBC. So intent of law is clear that assessment proceedings are also barred by virtue of moratorium. So that has been clarified in law now. So that is being clarified. So both these things can come to our rescue. So we can tell them ki yes, we are not going to provide you anything, because whatever claim you have to give only as on ICD or LCD. So you cannot go beyond that. So let them go, let this matter be adjudicated. We can take this stand.
Particularly has made CRP as a recovery mechanism.
So they are, you are right.
Even before the certified copy of the order comes, their request for information comes, that and they always want to do some fresh proceedings after CRP comes.
Yes, they are taking advantage of this situation. That is what we told them. They, what happened is IBBI had a round table of some IPs along with persons from EPFO department, the commissioner level and all those people were there. So Mittal Saab himself was present. So, so my question to them was, ki all these things which you are doing, tell us, is this money going to the real beneficiaries? Do you have the accounts or of those people? So you are just benefiting out of the loss of some other creditors. So how can you do this? So I have suggested to IBBI that at least what they can do is they can prescribe a format, this claim form for EPFO, wherein there should be mandatorily the column for account numbers of the beneficiaries, so that yes, so we know that this amount will go into that account, so that the department should not benefit out of this CRP. They are doing it. These EPFO persons, they are taking a real advantage out of misadvantage, we should say, out of the
Yes,
situation.
yes, they do not credit anything to the employees, and they take advantage of orders that have been passed to protect the interests of employees. And most of the calculations that they make at first instance, they will seek information and then they will make some presumptive calculation and send their claim.
Very right. In my matter, where 3 crores was adjudicated, while 20 lakhs was the original claim. So they themselves did some assessment without asking me anything on basis of the balance sheets, the earlier balance sheets.
Right.
See a record, and they said that this much was the turnover employees payment 8% के हिसाब से करके interest लगा के और वो लगा के and they gave it to me. So I said, how can do you know that these people were not existent at that time? You have taken an earlier balance sheet, say the balance sheet of 2014-15, and they said for next 5 years these were the salaries based on 14-15. There was no balance sheet of any date after that. So how can I make this factory was closed in 15 itself, and now you are taking the basis of 15 balance sheet and assessing the dues for 5 years after that, in which the factory was not existent, the company was not working. So how could you do this? So I did not accept it. So they have not gone further, and I rejected their claim of 3 crores, and plan has been implemented. And in another matter, I have taken a stand. I said, you give me the account numbers of the employees. So when they gave me account numbers, so I calculated the claim amount based on that. The claim amount is much lesser for the persons for whom the account number has been given. So I said, for others, I am rejecting it. So they have not yet gone to again to before NCLT for that. I have rejected. I said I will admit only for the for the persons for whom you have given the account numbers, because it is the employees' dues which are of the priority, not that the department should benefit. So
And in one
they
case,
have presumed that the employee cost is appearing very low, and therefore there must be some contract employees, and therefore they have taken 50% of manufacturing cost as contract employees cost, and we see that they have given their claim for PF.
Yeah, right. In another matter, this is also happening. So they are saying that contractors are there. I said you have to prove it that contractor, and also I showed them that the contractors themselves have given an undertaking that they will be responsible for making the payment of EPFO in our contract itself. So in that case, they have assumed also some big contract amount. So they are doing all that hanky pankies, just taking utilization of the situation.
in one of my case, sir, there was in the balance sheet, there was a acknowledgement that 12 lakh rupees is due to the EPFO on account of worker. That much only was there when I took over the company as a RP. There were no workmen, nothing was going on, but the last balance sheet had a 12 lakh payment. So the RA provided for that whole 12 lakh that this we will pay. Once this thing got approved, the resolution plan got approved, and this 12 lakh was supposed to be paid to them. So we went with the DD and all that. We wrote to them, this is your payment. They came back with some weird amount, again claiming about 1.5 crore rupees, saying that this is the presumptive amount and this has to be given. They did not accept the payment initially. After that, I think then I left it to the RA. I said, now it's your baby, just manage it. If you want to go to the court, I will be there in NCLT because it's very clear that your resolution plan has been approved. You have provided what was there and in full. Now they can't come and claim this. I think they have settled the matter in some manner, but this is happening very rampantly. Again, that as far as this, penalty clause in EPFO is concerned, where they're charging those quite high penalties, there also I had asked them, is it going to the employees So they actually said, no, everything that we earn actually goes to the employees. But they don't have the list of employees themselves.
Right. So that's
You're
why.
right.
So they
They
were,
don't have the.
they were answerless in front of IBPI chairperson also when we questioned that you tell us is it going, can you certify that all amount goes? They say 60. No, they said that around 40% definitely goes. So this was their own wording. So around 40% definitely goes to the
So then
employee.
60% why they should get?
They are earning. Yes, that's so Ravi Mittal Saab was also
If they
surprised.
don't, there cannot be a priority for 60%.
Yeah,
So
they
if they
said
cannot have any way of crediting to the employee, that cannot have priority.
yes, they should not have. So this 60% thing should be quoted. We should take from them somewhere in writing, that you are yourself acknowledging that 40% goes and 60% remains with the department.
No,
Sometimes,
another thing, one gentleman who was a EPF commissioner from South Hyderabad, he told me that this money that we take as penalty is basically we use to bridge the returns that we get on the portfolio from the investment and the extra return that we are supposed to give to the people. So supposing we are giving 8.5%, but by predominantly investing in government securities, our returns are smaller, than the 8.5%. Then we are using these kind of monies to bridge that. So ultimately, it is going to the employee may not be this particular company's employee, because we are a non-profit. We have nothing called a concept of profit.
they will get their salaries increased. They will be, having lavish offices and, all this when the department has the money with them, somehow they will definitely get benefited out of that. It's not only
Yeah,
that,
true.
definitely.
But this is the explanation he gave me. So
They give explanations, but in any case, why they are so desperately and also playing gimmicks by charging this PF based on the balance sheets of some earlier years, and
yes,
now
sir, they are doing that. They're doing that.
But this is also funny that they are, if a CRP starts in 2021 and they are making presumptive calculations of balance sheet of 2015, what they were doing from 2015 to 20 for their recoveries.
So why
They are
nobody?
just piggy writing the CRP processes and liquidation processes just because the law provides priority. But the spirit of the law is that the poor employee who has his life savings, he should not suffer. Not that the EPFO should come and get recovery and give a dent to the recovery for the banks and financial institutions.
Actually,
One question, Anil sir. How do you address the issue of gratuity?
no,
In the sense, many times there is no separate gratuity fund that is provided or kept by the corporate debtor who is already gone bankrupt. But as a liquidator, if the claim comes, we have to basically pay the gratuity. So how are you tackling that? Because I understand right now I have to pay gratuity to some people. I have kept the money aside, but I'm just waiting for this thing. So I have gone by their service records and things like that. Most of the uh, for want of any other data, because the data is attached by ED, and ED is as usual not releasing it. But the employees were able to prove a continuous service of 5 years in that particular company through their bank statements, through their salary slips and things like that. Many of them had. So we took them as gratuity. तो इसका अभी क्या है? हमें तो पेमेंट तो पूरा करना पड़ेगा इसका.
जी शास्त्री साहब, इसमें क्या है, यू आर वेरी राइटली सेड, मेरे क्या है, एक ही मैटर था मोजर बेयर जिसमें कि ऐसा इशू आया. All the other three matters, because out of my CRP processes, which around 45 processes which I handle the CRP, so in that only 4 has gone into liquidation. So out of those 4, 3 were already closed units, closed since long. So there was no claim for gratuity. Only one matter is Moser Bear. So that is a landmark judgment of Supreme Court also is there. So in that PF gratuity were held to be on priority, right? So till the Supreme Court. So I have paid the, I have paid the gratuity in full. Around, I think gratuity we paid around 30 crores in that account. So in
No,
only
so इसमें क्या होता है सर? जैसे I'll tell you again this same cases that I'm handling which I just mentioned. यहाँ 2018 से तो कंपनी बंद है, ठीक है? एम्प्लॉइज के क्लेम आए थोड़े से सैलरी के, बिकॉज द सैलरी वाज काइंड ऑफ अप टू डेट. Salary was kind of up to date before the raid happened and the guys ran off. Now PF was also up to date, so PF का as such कोई बड़ा claim नहीं आया. Now many of the employees have worked for 10 years, 20 years, 7 years, 8 years, so they claim their gratuity. Now in all fairness, just because the company had shut down in 2018, can it be said that their gratuity is also not due? क्योंकि 25 साल काम किया है, 20 साल काम किया है, 15 साल काम किया है, उसको अगर आप बोल देंगे कि भाई आपकी ग्रेच्युटी भी ड्यू नहीं है, सो माई व्यू वॉज दैट नो, ग्रेच्युटी नीड्स टू बी पेड, बिकॉज अगर कोई बंदे ने इतना साल काम किया है एंड प्रूव कर रहा है कि इतना साल काम किया है कंटिन्यूअस सर्विस, तो तब तो ग्रेच्युटी उसका बनता है. Only thing is that I'm just trying to take a clarification from the PMLA code, because PMLA code का कुछ अलग ही order है saying that everyone has to give an undertaking that they will pay back if this money is confiscated ultimately. तो वो तो कहाँ से workers देगा? So that is a बट ये मेरे को जानना था कि अगर समझो 3-4 साल पहले से कंपनी तो बंद हो गई है, बट लोगों ने काम किया है वहां पे, उनकी ग्रेच्युटी दी नहीं गई, इट वाज नॉट क्लोज प्रॉपरली जैसे होता है, तो तब उनकी ग्रेच्युटी तो बनना चाहिए ना. व्हाट्स योर फीलिंग?
इसमें एक मेरे केस में यू आर टॉकिंग अबाउट ग्रेच्युटी. In fact, the NCLT upheld that even the claim under other laws like payment of bonus act, etc., are also admissible simply on the tenure and if it is not paid. So, and in another case, these days, NCLT Chandigarh is requiring affidavit from the RA and the RP with respect to papers and that even if there is a provision for gratuity standing in the books, whatever the last audited balance sheet is there, maybe the CIRP is of 2024 and the last balance sheet itself is of 2020. Even if there is a provision there in the 2020 balance sheet and the company is closed for 4 years, 5 years, even then they are asking that you give a affidavit, whatever provision for gratuity is there, it will be paid in priority. To whom even that is not clear.
But in all fairness, should the gratuity not be paid? This is what I'm trying to take.
I agree with you that the gratuity.
क्योंकि अगर बंदे ने काम किया है 15 साल से,
the details
आज
are
तो उसकी जमा
there.
पूछ के
सर आप अगर उस बेसिस पे कहेंगे ना, थ्री फॉर लाइक थोड़ा सा काइंड ऑफ वी कैन टेक, आई कैन से अ सॉफ्टर एटीट्यूड और a little emotional kind of this thing. Otherwise, तो see, even the bank's dues must be paid because that also is a public money. So ये जो gratuity वाला है, I know the courts are taking the view based on this emotional outlook also that is a consideration. While मैं थोड़ा सा लॉ पॉइंट पे अगर आऊं तो 36, there is a little faulty wordings in this law section itself.
Yes.
जो मैं बहुत टाइम से वो कहता आ रहा हूं कि इसमें अमेंडमेंट होनी चाहिए थी. मेरी जब भी IBPI में भी बात हुई है, मैंने भी उसमें भी कहा, अभी नहीं हुई ना कोई. So basically 36 says the dues are of gratuity fund and employee fund, this provident fund have a shall be out of the liquidation state. While the liquidation state is any state for that matter is an state constituting of assets, not the liabilities. Any dues are not assets. Basically, it should have been worded the amounts lying in the gratuity fund or the provident fund, if any, that shall be kept out of liquidation state. Those are the assets basically. है, लेकिन इन्होंने यहाँ वर्डिंग यूज की है द ड्यूज. सो बेसिकली देयर इज अ फॉल्ट तो विच शुड हैव बीन एड्रेस्ड इन दीज अमेंडमेंट्स. तो वो इन्होंने आई डोंट नो पर्पसेडली उसको नहीं लिया या गवर्नमेंट डजंट वांट टू mess up with employees and doesn't want to come
No,
to.
I think what you are saying is correct. Correct. The government
Yes,
does not want to
that
mess
was
up
the
with
intent
employees.
also. So every
हाँ.
company has two options: either it deposits with EPFO or keeps a separate fund. But and the intent was only that that separate funds should not be utilized in the liquidation asset for distribution as per category. So what they have messed up
But
is that
then,
exclude whatever is due.
but many a times, what I have seen, many companies, they are not keeping separate gratuity funds, or even if they are keeping, they have utilized it elsewhere during their stress period. या तो पीएफ जमा नहीं करते
So
तो नहीं
taken
मिलता
और
policies for that
हाँ
liability.
वो पीएफ जमा नहीं
They have
करते, फिर
taken
कभी
some
कभी
policies.
वो
सर उन्हें सैलरीज नहीं दे पा रहे होते लास्ट के कुछ टाइम में के लिए तो
हाँ
पीएफ
हाँ
ग्रेजुएटी का
The moot point is that ultimately IBC has one of the objectives of credit promotion also. How will, as a credit underwriter or as a bank or financial institution, you will assess that if there is a default, what would be the statutory liabilities I will find outstanding if we read into my recovery prospects?
that is
And if that uncertainty remains, and the banks and financial institutions will eventually ask for more security or more interest rate, ultimately that does not benefit to the economy at large. Ultimately, the risk perception will be priced in.
very right.
It is only
नहीं, that's
exponentially. You will
true.
see the impact
That's
of 3 years or 5 years down the line when the banks will experience that they assess their security cover to be say 1.25. But when eventually the priority dues came in liquidation process or in CIRP, they did not even get 0.5, 0.6. They will certainly ask for higher security covers or higher interest rates going forward.
That's the problem, no? Yeah,
That
yeah.
might happen.
And as a lender, there is the TRA or there is a current account, so they can monitor the working capital. But can they monitor on a day-to-day basis the compliances also? That किस employee को 5 साल
As
हो गया,
a
किसका
Right.
PF कटा, किसका जमा हुआ.
They have this. There is a situation of uncertainty which should be removed, and definitely they should have addressed it in these amendments. That's why I'm saying, and definitely you are very right. So that lenders should be clear that as they whatever security they have foreseen before lending, this it should be intact, and not that any.
Everything at the time of liquidation or when they have to take recourse to that.
Very right, definitely.
In
So
fact, to that extent, in 53 they have brought clarifications, which brings the distribution.
हाँ, that is there in 53 they have brought the clarification. वो तो अच्छा clarification
तो
किया है, but
36 की कर देते ना 36 में तो और अच्छा हो जाता. But in any case, some I think that emotional, like Shantanu is also saying, that some emotional aspects,
थोड़ा it's a raw nerve. It's a
some
raw nerve
social
कि
aspects हो जाता
it's
है.
a social aspect of the whole
Social
thing.
aspect, yeah.
It
So
is a
now,
social aspect.
so there is a question
That
from
social aspect is also, being misused. As Anil mentioned, some white paper or some evaluation should come that whatever PF has recovered out of IBC processes, how much they have been able to pass on to employees.
So
If it
that
is just for this purpose of
will
unjust
also
enrichment, some RTI or some white paper should come out there, and government should evaluate whether there is any benefit of the 36 clause.
मैं बोलने वाला था कि एक आरटीआई करके पूछना चाहिए कि इसमें से क्या डिस्ट्रीब्यूट किया अभी तक जो 8 सालों में 9 सालों में है और कितना उनके पास पेंडिंग है. सो दिस विल हैपन लाइक इट हैज स्टार्टेड कमिंग इन द डिस्कशन. नाउ वी हैव अ शॉर्टेज ऑफ टाइम. सो एक लास्ट ये ले लेते हैं. देयर इज अ क्वेश्चन ऑफ आंचल जैन. Proposed amendment in definition of secured creditor will be different from view taken by Supreme Court. Fine, let us leave it on law. सो विक्रम बजाज जी और कह रहे हैं कि एनसीएलटी इज आस्किंग, वो आपने बता ही दिया चंडीगढ़. सो देन इज स्टेटस ऑफ कैरी ओवर ऑफ लॉसेस इन केस ऑफ सेल एज अ गोइंग कंसर्न. तो ये हमारा एड्रेस हो गया. सो लाइक इट इज एड्रेस्ड बाय वर्च्यू ऑफ अमेंडमेंट इन इनकम टैक्स एक्ट. So fine. I hope that we have been able to share our experience to the best. So so any other question? Any question from anyone else? Or we can wind up. Fine. So thank you very much. Thank you, everyone.
Thank you, sir. Thank you, sir.
Thank you. Thanks a lot.
I look forward to you sharing that soft copy with me, sir, of
So
the
I'll do
replies
that.
that.
I have already instructed. Yeah, we'll definitely. Definitely.
Thank you so much. Thank you. It will be a good help.
Yeah.
And
Thank you.
anyway, I can help you. You please be free to just
Definitely.
let me know.
Fine, definitely.
ठीक है, sir.
Thank
Thank
you.
you very much. Thank you very much.
Thank
Thank
you,
you.
ICSI, for giving me this opportunity. So thank you all the participants for participation. Thanks a lot.
Thank you. Thank you.
Thank you. Thank you.